So in law school, there are different types of writings you'll be expecting to do for grades. These are assignments and exams, which are closer together than not. Then you also have to do legal writing like memos and factums. Write a couple of essays. These can be self-reflections and what you've learned during the course. The most common types of assignments, however, involve you writing a judgment for a case with you as a judge following the tests that are laid out from the course. Or you'll be writing for one side to the judges on why you should win your case following the tests that are laid out. Basically, write using the test that's laid out. LDR, there's a test, use it right. Basically, there will be a test that the Supreme Court has laid out for lower courts to follow, and it is your simply to apply the facts of the one case to the test. These basically follow your science lab structures. My hypothesis is this. The first test to prove my hypothesis is this. The result is X. We move on to the next step because of X observations, i.e., in legal terms, this idea in the law. Professors are trying to see if you can apply the test to the cause using legal reasoning. Keep it simple and show that you understand the arguments at any step. We'll mainly focus on the text of the laws using the framework that was set out by the majority's findings on the interpretations of those words in the given test. For example, there's a little bit of overlap since you will be writing either a judgment or taking a side after a case presented to you. You will then develop an answer to the question posed to you by writing an answer that is outlined by the test that you have been taught in classes while also using the reasoning from other cases covered in the class to back up your decision. There will also be an amalgamation of different issues in the one fact pattern that will pull from all areas of the class, unlike in the assignment where you will simply be pulling from either one unit or one case. You will also be expected to write out the thesis of different units that were presented by the professor, basically explaining the two sides of the different legal theories and what side you fall on while addressing the good points of the others. To do this, you will address both the majority's and minority's judgment and explain the nuances of each position and how each side applies or does not to the case at hand. This is like compiling the results of your lab into a lab report. You're recapping the steps in your analysis therein while also being required to explain through legal reasoning why something else was not the result, why the penny turned green and did not stay the same orange color. You're relying both on the observation of the text as well as the grand idea of science, instead of simply pulling on the idea that a balloon floated away, thus the gravity has no power. You will instead say it is true that the balloon in this case was able to float, but we also see the person who was holding the balloon is affected by gravity. We can then conclude that each object is affected by gravity, but we have to prove why this is the case. These are where the majority decisions and the minority's decisions come in. It's a bit of a far idea, but basically you're just saying why the result is the result, the observations, or the judgments that you've covered in class. The concurrence, dissents, minorities are going to give you the logic as to why things are a certain way, even if that does not appear to be the case. These two types of writings follow a pseudo-IRAC structure within the tests themselves. The issue that is presented in the facts. For example, was Mr. Walker acting voluntarily when he stabbed his mother-in-law while sleeping? The reasoning of the court's minorities and majorities and dissents decisions that you covered in class will then recap the reasoning of the court's majorities, dissents, and minority decisions that you covered in class, then apply those strands of reasonings to the facts in your current case, which is going to be your analysis. You will always give deference to the majority since that is the law. For reaching your conclusion on this issue and then moving on to the next issue. Each of these issues will have to do with determining the answer to each part of the test. In this way, while assignments focus more on the issue and analysis steps, since you are being tested on your legal reasoning, exams focus more on if you understand the debates presented in the class, cases you read, and how you balance these approaches with the case at hand before reaching your conclusion using your legal analysis as you did in the assignments. Legal writing in your memos and factums are a bit different. You'll be presented a case and you'll have to go out and look at cases and find some cases that have the results as you want, which are binding that follow the same fact matrix. To present a thesis at the beginning, then go through presenting evidence as to why you think your hypothesis is right. Evidence will be each case you brought that decides the issue in your way. Most memos and factums focus on one very specific issue as opposed to the assignments or exams to focus on multiple issues or conglomerations of similarly situated issues in the same test. Writing is mainly showing the similarities between cases and why those similarities are important because of the principles of stare decisis. This basically means that like cases must be decided alike. For example, if there was a case where throwing a baseball at somebody was constituted assault, you would expect that if somebody else threw a baseball at somebody, that would also be assault. Your job in these memos and factums is to determine if throwing For example, a tennis ball at somebody would be assault. Slightly different, but with the same basic fact matrix. You use the CREAC structure to show why a decision should be reached, or hypothesis or conclusion, followed by the general rules that you learn in class. In general, this thing is always true, then you explain that rule. Assault, for example, assault is when you do bodily harm to somebody. It doesn't have to be physically. You can do it by a weapon that's under your control, for example. Analysis then would be providing, in so-and-so case, the court determined that all of these different balls were weapons because they were under the control of the assaulter, they had the capacity of doing damage when they hit the victim, etc., which is why they're assault. You then look at the similarities to your case. For example, Mr. Pitcher had control over the ball at the moment that he threw it at the victim. He did so voluntarily, so it was a weapon according to the judgment in so-and-so case. Mr. Pitcher, in another case, might have also met all the criteria of assault because the victim suffered from these injuries. So did the victim in that case. You're basically pairing like and like to show the judge that they had to follow these rulings because the facts are so close that stare decisis must apply. Finally, you restate your conclusion and briefly go over why. This is the only writing in law school where you have to show that the facts are alike and to apply conclusion from another case. Do not do this on exams. You're wasting time and space. The cases you cover in exams are so apparent to the general law society that they stand solely for the principle. So don't even bother citing them because they are just accepted in most cases. Ask your teacher, but usually this is what they'll tell you. Memo or factum, you are arguing the minute details which require not the analysis of the big picture, but of the details, which is why you have to compare point to point. You will also defend off the arguments of the other side by pinpointing the differences in the facts of the cases to yours, and why thus the one change in the cases that they're bringing makes the reasoning of the judge of that case invalid to the current case. Basically discarding why the judge should follow stare decisis for their side. Okay, so ramble over. I will probably redo this video later to make it more clear, but since it's just starting out, it's fine. The TLDR of it is assignments in law school are mostly self-reflections or to see if you can follow the test laid out in the class in relation to the facts of one case. I'm focused on how well you understood the debates posed in class and their place in the test you learned in relation to the big picture ideas of the class in relation to a set of facts. Meanwhile, legal writing focuses on finding different cases that support your conclusions because the details of the cases are aligned and thus, using the logic of the case, they should be decided the same. Think and apply text assignments. Tackle the nuances of debates and come to a side, exams. Distill the reasoning of judges to explain why you're factually similar, favorable case. Legal writing.